minutes by my watch to see if he or anyone else of interest comes along. Is my there's one. Okay. Let me get my Scrivener tools out. Okay. How are things down in the southeast?
They're they're very good. They're cold. They suddenly got cold. I've been out for a little while. I just got back this weekend, but it was warm one day, and now it's like to me, it's bitterly cold.
Yeah,
Very,
same thing.
very cold
Yeah,
outside.
same thing up here.
Very cold.
Yeah, definitely cold in Santa Fe.
I would guess. All righty. What today is the 5th of December. All right. It's now 9 o'clock Mountain Standard Time. So we'll call the meeting to order and call the roll. Commissioner Baker,
Present.
Commissioner Bluestone,
Here.
Commissioner Castillo,
I'm here.
Commissioner Klingman,
Here,
Commissioner McMillan is not present. Is he excused, Jeremy?
He had a commitment that he had told me about, so I was aware that he wouldn't be here.
Okay, if we're aware of it, then I'll call that an excusal. And Commissioner Villanueva,
Yes.
and the chair is present. So we have quorum. Item number 2, approval of the agenda. Is there a motion and a second?
So moved.
Any
Second.
discussion? Anybody opposed to the agenda that we have before us? Okay, then the agenda is approved. Item number 3, approval of the minutes of our last meeting, which was October 10th of this year. Is there a motion and a second?
Move to approve the minutes.
second.
Any discussion? Okay, any objection? If not, then the minutes of the meeting of October 10th, 2025 are hereby approved. Next, item number 4, the annual report. That's Jeremy and Amelia.
Okay, thank you, Chair. Good morning, Commissioners. Let me start by saying that, as you know, the team is headed to Atlanta for the Council on Government Ethics Laws, our annual COGL conference this next week, and I'll need to leave the meeting a little early to catch a plane to Atlanta. So, but I'm here to present the annual report to you. This, as you know, is one of the Commission's statutory responsibilities. Every year in December, the Commission has an obligation to submit an annual report of its activities and any recommendations for legislation to the governor and the legislature. And the way this ordinarily works is we draft an annual report for your review and approval. And at the end of December, after we have our final numbers on complaints and advisory opinions, we plug in our final numbers for the year and send it to ordinarily the governor's chief of staff and the head of the Legislative Council Service. And the annual report is kind of kept in the legislature's repository of materials. So you have before you the draft annual report for 2025. I'll just hit some of the high points of note for this year, 2025. So this year's significant in that we transitioned general counsels. So our first general counsel, Walker, after serving a full 5-year term, moved on, and we hired a new general counsel, Zach Goodrich, who came to us from Iowa, where he was the executive director of the Iowa Ethics Commission. And it was very gratifying for the commission as a state ethics commission to be able to recruit from someone whose profession is government ethics laws and had leadership experience in another state's ethics commission. That was a real win, I believe, for our state's ethics commission. So that's one kind of high point of this year. We made our first transition in the general counsel role. Second, although the numbers are kind of in blank, waiting final approval, or just the final tabulations, the commission has received an incredible increase in complaint volume over 2025. Our administrative complaints are holding about per normal. So far in 2025, we've received 40 administrative complaints, and we're kind of on track for a normal amount of third-party administrative complaints. But the kind of informal complaints that members of the public can also file, which triggers the commission's discretionary review and discretion to approve civil enforcement actions. That complaint volume is way up. So far this year, we've received 418 informal complaints that we worked through, and I think by the end of December, we'll be on track for 450 or more informal complaints. So the complaint volume that the commission is receiving is way up, and we've had to kind of especially staff and figure out how to handle that kind of complaint volume and present to you only matters that we feel very confident are deserving of the commission's approval for civil enforcement. So those are I guess two of the biggest matters. Everything else is proceeding normally according to pace. As you'll notice from our meetings, our agency is more divisionalized. There's more of a delegation and clarity in roles, and that just reflects how the agency is maturing. Commissioners, I'll close before I hand it over to Amelia to go through legislative recommendations out of 2025 with our fiscal report. So again, this year, thanks to all the work that Wendy and Sharon do behind the scenes on the administrative services side, the commission received another unmodified audit opinion. So I believe that's 6 years running where the commission has had a clean bill of health from our external auditors, CLA. That's not public yet. I think it has to be approved by the state auditor's office before we can publish our fiscal year 2025 audit. But it's a remarkable achievement year over year, especially as now the commission is handling about $2 million a year in public money. So if the commissioners look to page 19 of the executive materials, this is our fiscal report. I just want to touch on this briefly because it's different in one important way from prior fiscal years. It's a statement of the revenues the commission receives, which our revenues are slight. It's settlement money that the commission receives in addition to the revenues that we receive for teaching courses through New Mexico Edge. The expenditures is just the ordinary expenditures that the commission kind of tracks in the every other week or once a month. I send the commissioners a kind of statement of where we are in our budget projections, and those expenditures reflect the commission's expenditures across all categories for fiscal year 25. And then the other financing sources at the bottom of this page is both a statement of the amount of money that we receive from legislative appropriations, both in Section 4 of HB2, but also in Section 8, which are the compensation increases. But our fund balance this year is larger than in ordinary years. It's up to $80,000, and that's because the commission has received a special appropriation that's good for several fiscal years. And so we didn't spend, maybe a quarter to a third of that special appropriation in FY25, and we're able to kind of carry that over into fiscal year 26, and I believe also into fiscal year 27. And so we have a special appropriation that's authorized for several fiscal years that we're carrying forward, and that really helps us cover some expenses that we're beginning and will need to transition into our ordinary recurring expenditures and recurring appropriations to fund, such as our expanded lease space. But this also is helping us this year, for example, to send the entire attorney staff, in addition to our deputy director, to Kogel, and that's just remarkable that our entire staff can go to our entire attorney staff can go to the National Affiliate Government Ethics Laws Conference. And so our fund balance is larger than the commission has seen it before in our kind of statement of our fiscal report. And so I just wanted to direct the commissioner's attention to that. And with that, Chair, I'd like to turn it over to Amelia to kind of review the legislative recommendations that are coming out of 2025.
Thank you. Amelia?
Thank you, Chair, and thank you, Jeremy. Good morning, Commissioners. Many of the legislative recommendations that you'll see in the annual report are recommendations that we've carried over for many years now. And so I think this morning I'll just spend time on two recommendations that are new, that you're seeing for the first time. The first is a set of recommendations for improving local campaign finance and disclosure authority. So neither the Campaign Reporting Act or the Financial Disclosure Act extend to municipal elections or to many other local officials. And so as a result of that, only home rule municipalities possess the authority to adopt their own campaign finance and financial disclosure ordinances. And because of that, and also because of some of the feedback we heard at the local ethics forum that we held about a month ago, the Commission recommends amending both the Campaign Reporting Act and the Financial Disclosure Act to explicitly authorize municipalities and counties to adopt and enforce supplemental local disclosure provisions. That is one of the new recommendations we're putting forward this year. And the second recommendation that is new to you all this year is a recommendation for amendments to the Lobbyist Regulation Act. This recommendation really comes out of recent learnings that came from an enforcement matter over the summer. We received an informal complaint that there was an organization not disclosing a lobbying campaign advertisement. And based off of the way the statute is written currently, we weren't able to confirm whether or not those expenditures were really being reported until after the session ended, because that's what the statute required. And so based on these lessons, the Commission's recommending amendments to ensure that the disclosure happens before the legislative session ends, when disclosures are most important. So those two recommendations are new to you. Every other recommendation that you're seeing there in the report is a recommendation that we've made in a previous year.
All right, thank you. Is there a motion and a second to adopt the annual report?
So
So-
moved.
Moved and seconded. Discussion? Stuart?
Yes, thanks. Appreciate the work again and the report. I just have a few questions. Jeremy, when you talked about the substantial increase in the informal complaints, can you describe for us either subjectively or otherwise what you think those complaints are indicating, and why you think there's been such a substantial increase, and if you can characterize them in any way for us to get a sense of the subjects and the areas that are being addressed?
Sure, happy to. So I think that we've received the increase, or we've noticed the increase because we've made this portal available. So these are whistleblower type allegations that, unlike the third-party formal complaint process, don't require affirmation under penalty of false statement. They can be anonymous. They do not have to be formally sent to the respondent and then risk management counsel if the respondent is a state employee. So it's a way for the public to, without swearing to the allegations under penalty of perjury and filing a formal complaint under the strictures of the State Ethics Commission Act and 1.8.3 to alert the commission as to what they believe is happening either in their agency or in their communities. And I'd say about 2/3 of these administrative or these informal complaints are concerning allegations at the local government level. And as the commission knows, the State Ethics Commission Act was enacted and has continued to not grant the commission personal jurisdiction for any officials or employees at the local government level. And so this is really the only way for the commission to be alerted toward allegations of ethical violations or procurement violations or other kinds of discrimination or just other sorts of problems at the local government level. So I think I would, ballpark roughly about 2/3 of these as being allegations about the local government level. They come from individuals from all over the state, and it's actually quite, well, it gives me comfort, I think, to pair observations about what is happening in government ethics in Washington, D.C. versus seeing the traffic on this informal complaint portal at the local government level in New Mexico, where it's very obvious and clear that a baseline understanding about self-dealing and conflicts of interest and just propriety of government ethics is still very much alive and well in our culture, and we see it weekly through the traffic on the local government or just on our informal complaint portal, and that kind of gives me a lot of comfort. So I would say about 2/3 are addressed to issues at the local government level. The other third are either state agencies or just matters that go well beyond the commission's remit, either conduct by a private actor or perhaps by a federal actor. I think, we're almost always involved in referring some of the traffic of this portal. Much of it is matters that probably don't rise to the commission's attention, either because the statutes don't capture the conduct or even in instances that we do, we also have to kind of make discretionary capacity oriented decisions about this portal. But we do receive very, very significant matters. And I would also say that some of the most significant matters that we receive, we're beginning to receive as referrals from other oversight agencies. In particular, the Office of the State Auditor submits a lot of information that makes its way onto this portal. And we're beginning to receive referrals from the New Mexico Department of Justice as well. And sometimes we refer things that direction. We've recently referred a matter to the U.S. Attorney's Office that was purely federal. And so it is the kind of air traffic control on enforcement right now for our agency.
And thank you for that. And we've certainly taken significant actions in the past based on confidential, anonymous referrals received. And even as to local government, officials and employees. We've taken actions under the Governmental Conduct Act. Can you generalize a percentage of these referrals that result in the commission taking action?
As a percentage, I would say less than 5% of what hits the portal to what you approve for the filing of a civil lawsuit.
But some of our most significant acts have come as a result of that, wouldn't you say?
Absolutely. Yes, absolutely. Yeah. And what we present to you for requesting for authorization to go forward on a civil enforcement action, is absolutely the most significant matters that come in through the informal complaint portal.
Okay. Thank you for that. My next questions are for Amelia. But I don't know, do others want to address things for Jeremy first?
Go ahead, Stuart. We'll do it just one person at a time.
Okay.
Thank you.
As to the legislative recommendations, I'm curious if you could explain what groundwork has been laid, what contacts have been made to try to get legislative support for either sponsors or going to interim committees to talk about these issues. Can you just kind of give us an overview of what work has been done to lay the basis for a bill to be introduced and to get support in the coming legislative session and in the next 60-day session as well?
Thank you, Chair, and thank you, Commissioner Bluestone. As you know, the next session is a 30-day session, and we haven't done a ton of prep work for the 30-day session, recognizing that it is short and largely will be based around the budget. And so we haven't started planning yet for the 60-day session, but I imagine those are discussions that we'll start to have soon. And especially heading into the COGO conference this next week, it's a time where we're really able to share ideas and learn from what others are doing. And so I think over the next couple of months, we'll really start putting our heads together, planning for the next 60-day session. Jeremy, I see you have come up.
I am muted. I can comment on that a little. So Representative Cates is interested in the legislative idea to give formal authorization to the municipalities and local governments to adopt their own financial disclosure and campaign reporting act regulations. She did attend the local government forum that we held here at STP, and I think was receptive to that idea. So for that piece, I think that's a potential sponsor. I have not made an ask of the fourth floor yet to include these ideas on the governor's call. This is the governor's last session to kind of get done what she wants to get done in her term as governor. And but I do believe that the commission's work on the Lobbyist Regulation Act, Section 6I, and the enforcement action that the commission took over the summer, I've been told has helped give momentum to some of the medical malpractice and healthcare provider bills that we're likely to see on the call in the 30-day session. And so I think that the commission's work in 2025 is very much involved with what the legislative agenda will be in the upcoming 30-day session. And then as to our work at interim committees, we were invited to present on the work the commission's doing in attempting to get clarity on the enforceability of the Non-Disclosure of Sensitive Personal Information Act statute, given federal immigration law. And we have participated in the kind of very important courts, corrections, and justice interim committee And I don't believe that that committee will be doing any work on that particular statute in the 30-day session. But yeah, we have been involved in the interim, and the commission's work in 2025 is I believe feeding into what will be at issue in the governor's very last legislative session.
Thank you. Yes, I know that as for every legislative effort, there's a lot of homework that has to be done to lay the groundwork for successful passage. And I recognize that this is a short session, but you can't get started, in my mind, soon enough in terms of garnering support and looking for sponsorship for each of these issues. The one that I'm particularly curious about is after the governor's veto of the lobbyist regulation bill, have you had any overtures from either of the sponsors about any work that's been done to address the governor's veto letter and whether there's any effort underway to bring back anything along the lines of what was addressed in the last session?
I have not had a conversation either with Representative Silva or Senator Steinborn about an attempt of theirs to address the governor's veto during this gubernatorial term. I expect that bill to come back maybe in the next, once there's another governor on the fourth floor. But yeah, following that veto, my impression is that legislation is on hold for a little bit.
Okay, thank you.
Thank you. Anyone else? Yeah, so
I just, I brought this up to Jeremy, and I don't know if we need to do something about it, but page 19, Casey's name needs to be changed to Chato.
Thank you,
Okay,
Chair,
thank
and
you.
thank you, Commissioner Castillo. Jeremy did pass along that comment, and we've made amendments on our end.
Okay, great, thanks.
Thank you. All right. Any other questions or discussion? Okay, seeing none, there is a motion and a second to adopt the annual report as put forth by staff. We'll go ahead and do a roll call vote on this. Commissioner Baker,
Yes.
Mr. Bluestone,
Yes,
Mr. Castillo,
Yes,
Commissioner Klingman,
Yes.
Commissioner McMillan is excused, Commissioner Villanueva,
Yes.
and the chair votes yes. Thank you. Thanks for the good work, everybody. The motion carries and the annual report is hereby adopted. All right, item number 5, potential recommendations for amendment to NMSA 1978-1016 G3H. Commissioner Baker, and I believe Jeremy is going to head off to the airport. So Amelia, you're steering the ship solo now. Commissioner Baker?
Thank you. As all of you know, the commission is comprised of 7 members, 3 from the largest party, 3 from the second largest party, and 1 other. I am the other. And the way that the legislature created the Ethics Commission, it did so in a way which said that a quorum requires 2 from the largest party, 2 from the second largest party, period. Which means that the other commissioner's presence or absence is not relevant to whether or not there is a quorum. The legislature also said that essentially, in order to pass anything, you need 2 from the largest party and 2 from the second largest party, period. What that means is that 2 from the largest party or 2 from the second largest party can kill anything. And although this commission has, since its inception, been very collegial and productive, there have been occasions when two Democrats or two Republicans killed a proposal. So the final vote was 5 in favor, 2 opposed, but because the 2 opposed were from the same political party, the matter died. And so my question that I asked myself was, when my position becomes vacant and the commission advertises for a replacement, it seems to me that it would be appropriate to tell applicants, we're happy to have you apply, but your presence or absence is meaningless with respect to whether or not there is a quorum, and your vote will be meaningless with respect to whether or not anything passes. I've sometimes referred to myself as the potted plant. More recently, I have only to myself referred to myself as the eunuch, or whatever the singular of castrati is. But that's the way the legislature decided. And I'm guessing, and it's only a guess, is that New Mexico, which was very late in adopting an ethics commission, one of the last states to do so, that the legislature wasn't really sure about how this ethics commission would operate. And it wanted to put some guardrails in because it did not want to have created something that would be out of control or would run roughshod over other parts of government. And I get that. I think that what has happened should put that concern to rest. Obviously, it always depends on who the individuals are. But from the beginning, this commission has operated, I think, in a very appropriate manner, most likely because of the quality of the people on the commission, and because the commission wisely, in my view, hired Jeremy to be the first executive director and to put the meat, if you will, on the bones of what the legislature created. It might not be a good analogy, but if you were to have a Supreme Court or Court of Appeals, which said we want to have X number of Democrats and X number of Republicans on the court, and we want independent, but the independent's vote doesn't matter. The independent is allowed to review matters, participate in discussions, but we don't really care at the end of the day what that independent Court of Appeals judge or Supreme Court justice decides. That might not be the best analogy, but it's the one that comes to my mind. And so then the question is, well, what are we going to do about it if we decide to do anything about it? And I told Jeremy about my discomfort, and Jeremy asked Casey to look into the legality of how the legislature created not how they created, but what they created with respect to the Ethics Commission. And I told Jeremy, I told Casey, and I want all of you to know that I think what Casey produced is incredibly high caliber. I think that her legal analysis of the constitutionality of what the legislature did was first rate. And I even suggested that if she is interested, she might want to see if it could be published as a law review article. I think it's that good. So if a constitutional challenge is not going to make a change, make a difference, then the question is it worth going to the legislature? Clearly, the legislature will have a lot on its plate in a short session. They will have a lot on its plate a year and some months from now in a long session, but is it worth putting out there and letting the legislature chew on it and decide what they want to do? Again, in the context of whether or not they're going to allow municipalities and counties to do things with respect to the Campaign Finance Act, Campaign Reporting Act, and so forth. I'm guessing that if those smaller public agencies create ethics commissions, they might want to use the state ethics commission as a model. And do we want to perpetuate the 2 Democrats, 2 Republicans, and 1 potted plant as New Mexico's model for ethics commissions? And so I'm interested in feedback from members of the commission. What do you think? Is it worth asking the legislature to make a change? And if so, what kind of change? And so that's what I've got.
All right. Thank you. Anybody want to weigh in? Anyone else want to weigh in?
Sure.
Go ahead.
I want to thank Jeff for raising the issue, which I think we've been aware of since the inception of the commission. But I think that the memo that you prompted for KC to do resulted in an excellent piece of scholarship. And I agree with you about that. And I want to commend her and thank her for that excellent work. I think that it is an issue that definitely needs consideration. And I think that there are various ways it could be addressed. I don't hear any particular proposal from Jeff on how to address it, but I think that there are different options that could be pursued, and I think it's worth studying and thinking about and getting feedback on. I mean, you could obviously have a different voting system. You could have a simple majority with just at least 1 Democrat and 1 Republican to ensure bipartisanship, and then the vote of the independent member would be weighing in on that too. Or you could have a super majority of 5 or even 6 votes, and you could give the minor party or independent member even a veto power. And there's a lot of different ways that this could be addressed. What I would recommend is that, and I guess it's Jeff who has brought this to the attention of the commission today. There is a group, well, there are actually 2 groups now that I'm aware of in the state that are advocates for the independent and minor party members. We just had the adoption of the open primary that allowed others to vote in the Democratic primary and the Republican primary. And there's a group called New Mexico Open Election that I think Bob Pearls was the one who co-founded it or founded it. And they've been very active in working to get representation of the independent and minor party membership, which, as you said, Jeff, I think is about a quarter or a third of the electorate, maybe even more, I'm not sure. And I think Bob Pearls also just started another organization along the same lines called New Mexico Forward Party that is also focusing on the representation of the minor parties and independents. And so I think it might be worth you looking to other allies like those groups that are advocates for the independent and minor party members and see if there's a way of forging some proposal on how to address it. As I say, I think there are various ways it could be addressed, but I think it might be worth it to get others involved and then possibly again get the staff of the commission and the commissioners again to be involved in in looking over proposals. But I think it's an issue that's definitely worth considering, and I think it needs more study. And I'd be open to hearing different proposals and working with you and others on it as well. But I think it's an issue that I commend you for bringing forward, and I think it's worth continuing to give attention to. So thank you.
Thank you. Anyone else? Celia?
Yes, I agree with Stuart. I think Casey's opinion is just outstanding and certainly gives a lot of direction on this issue. I wanted to ask Jeff if he had any proposed solutions, but I like Stuart's idea better of looking into it and see, because, you know, as I looked at it, I agree there are lots of different ways to look at this. So anyway, Jeff, did you have any specific proposals, or you like the idea of doing this study?
Well, my suggestion would be majority rules, that we have a 7-member commission, and if we want to have a quorum, we need 4 members. And if we want something to vote to pass, we need a majority of those who are present. And I don't care what party they belong to. I don't care if they belong to no party. And with all due respect to Stuart, the best way to kill something is to study it to death. I mean, it's not complicated. I would ask Stuart, because I'm guessing, but I don't have any concrete evidence, but I'm guessing, Stuart, that you were involved in the creation and passage of the Ethics Commission Act a number of years ago. And I'm guessing that you were in conversation with legislators who might have been nervous about what this new entity might turn into. And am I correct in thinking that there were a number of legislators who were, I'm not sure what the term is other than nervous, about what this new thing would do and how it might operate? And it's the best way to put some guardrails was to say 2 Republicans or 2 Democrats can kill anything, so we're not going to let this new organization get out of control. Am I being unfair in thinking that that was part of the conversation?
I really wasn't a party to those discussions, Jeff. I mean, I remember working on proposals years ago that create an ethics commission, but I wasn't involved in what came out as the 2 Republicans, 2 Democrats having the veto power. I mean, I think, yes, there were always general concerns about creating an ethics commission and what it could do, and there were concerns that hark back to the old organized crime commission and people who felt that ran amok. But I really wasn't involved in any of the discussions that led to this particular proposal, and I can't really comment on what the genesis of it was. I think it's unique around the country, as I understand it, but I can't really shed any light on how it got generated.
Unique because 2 Republicans or 2 Democrats can kill anything?
Well, I think unique in the way it's appointed, by the,
okay.
And maybe that too, but I was thinking unique in the sense of the 4 legislative leaders appointing 4 members, and then the 4 legislatively appointed ones appointing another one, and then the governor appointing the chair that has to be a retired judge. I think that's unique around the country, but Jeremy or Amelia can probably comment more about that.
And I have not spoken with Zach, but I will. I'm curious as to how the Iowa Ethics Commission is comprised, how it's selected, and is it 1 person, 1 vote, or some other formula? And I mean, we could do I suppose a 50-state survey. I don't know if all 50 states have ethics commissions, but to see what they do. It seems to me like a lot of work to solve a small problem, but we could do it, I suppose.
Anyone else? Yeah, Judy.
Yeah, I would just like to kind of piggyback onto a question that Jeff was mentioned. I really don't know the intent of the committee that put this proposal together. I don't know if they wanted to maintain control. I think one of the things they need to look at is in identifying the first and second largest parties. They need to look at what's happening. So I took in terms of the voter registration. I took a look at the statistics and the demographics this morning. Whereas I have the entire state, I didn't have enough time to look at it, so I looked at Ada County only. I was looking at the registrations in 2023, and the new registrations predominantly were do not DTS, decline to state. Now on the registration form, you have an option that says no party. So when you check no party, you go into this category that says no party. It says no party, independent, and decline to state. So there's kind of this mixed category where independents fall in there. So frankly, Jeff, as you came into the commission, I really wouldn't know what you were if you came in as a DTS person. So as a DTS person who declined to state, you may very well have inclinations towards Democrat ideology or Republican ideology. And the point I'm trying to make is that on the commission in the future, there could be as many as 3 individuals who are not of the parties that we know are the majority parties, first and second majority parties, because the decline to state in this county where it's very conservative, we expected to see a very high volume of Republican voters, but we had a very high volume, mainly consisting of university students who declined to state for whatever reason, whether they wanted to be coy about their identity or maybe they really had no ideology to state or to follow. But I think my sense is, if I remember, is that same thing happened in Albuquerque, in the Albuquerque area, and also in the Las Cruces area when I was kind of looking at trends. So the DTS may well be a major party. So I just kind of want to throw that out. And when we talk about minority parties, I think, Jeff, did you come in as an independent or?
I came in as declined to state,
Okay.
and just my personal history. At one point, I was registered as a Democrat. I got fed up with the Democrats. Then I became registered as a Republican. I got fed up with the Republicans. And then I wanted to vote, so I registered as essentially none of the above, which in New Mexico means declined to state.
Let's see. Well, well, that's part of my, and I don't know what the intent of the legislature was to block out those kinds of votes or give you no representation. But in addition, my concern would be is in the future, we really don't know what the composition of the electorate is going to be in terms of parties. And so maybe as a whole in the next couple of years, they might have to look at this because the DTS party the DTS voter registration is very, very, very large. And I imagine in the next election, it will be even larger. I even looked at the crossover registrants, and a lot of those who were party affiliated went into the DTS category. So I think in the future, there are things to think about. But I will say this, I have served on this commission for 6 years, just as Jeff has, just as Chairman Lang has, and Commissioner Bluestone. And during that 6 years, I have to say that I do believe that it's the composition of the individuals who sit on this commission at this point in time that make me say that I do believe that Jeff's vote and participation is worthy of considering him in the balance of the decisions that we make. So, having said that,
Well, thank you. Obviously, when I leave, y'all could select somebody who's a knucklehead and say, boy, that was a mistake. But part of it, again, is when I leave, you're going to advertise for my replacement. And I would think that it would be appropriate as part of disclosure. Oh, by the way, your presence will not count one way or the other with respect to a quorum, and your vote will not count. But we welcome your application nevertheless. And
Well,
people are going to look at that and they're going to go like, whoa, what am I doing? Why am I doing this?
I have a
So-
question and a comment.
Sure.
So I guess my comment first is Jeff, I think your participation on the commission with respect to me has really been valuable. On some of my views, you've dissuaded me and you've persuaded me. So I felt that your participation was exceptionally valuable to me, as everyone else's input has been.
Well,
The
thank you.
my question to you was, when you applied, were you not aware? Did you not read the
When I first
statute?
applied, I was not aware. I did not read and understand how this organization was going to work. And maybe there were others who from day one knew exactly what the mechanisms were and how it was going to shake out. I did not. And maybe I'm just a slow learner, but over time I got a better feel because that's the way I learn. It's sort of experiential as opposed to being able to read something and be able to foresee this is how all the pieces are going to come together. But it's a valid point. Why did I reapply, knowing that my presence was irrelevant with respect to a quorum and my presence and my vote was irrelevant? Partly because I find it very interesting. And I enjoy the people who are part of the commission, and I'm proud of the commission. I am proud of, and I'll use the collective we. We built what I think is an impressive ethics commission, and we've done something which I think is good for the state. But like anything else, it's evolving, and we need to see if there's a way to make it better. And as Stuart, I think, is suggesting, there's also a way to make it worse.
Right.
So
Anyone else? Thank you. Judy, is that all?
That's all. Thank you.
Thank you very much. Anyone else?
Oh, may I make one other comment?
Of course you
I
can.
just wanted to thank Casey. That was an intensely comprehensive piece of work.
Yes.
And very, very, very well done.
Yeah. And I think that goes unsaid. Therefore, we may need to say it, Casey. That wasn't, even by your standards, which are pretty high, very high. That was an extraordinary piece of work and very helpful. I think we all agree that what Jeff has raised, we probably all missed, at least speaking for myself early on, until he raised it to my attention. But it does seem that some type of expression to the legislature to point out the awkwardness, if you will, of the non-voting participation in any meaningful way of the independent. Two things come to mind. One of them is that there is a move recognized in the legislature by its recent passage of the bill affording independents to the right to vote in a primary. And I don't think that's going to diminish the number of people changing their registration. If anything, it will encourage more because at least you get to vote in a primary, which you couldn't before. And that probably kept a lot of people from doing it. And second, it's the Occam's razor theory that whatever we do should be very simple and put forth the proposition that the independent should vote and count towards a quorum. Anything else, I think, becomes what is it, a Russian rope? You pull the string and all of a sudden you've got five loose threads running around, because if it's an odd, well, it was put together by a committee to make sure the thing got through, and I get that, but we've seen how this works, and perhaps the simplest answer is typically the best. Again, the Occam's razor theory, that we simply afford that individual the opportunity to vote, and a quorum consists of 4 of the 7 people. Pretty traditional, and it's served the country pretty well for the last couple hundred years plus. But those are my thoughts. I think this year is would be a waste of time and energy. We don't really have a plan, but we need to come up with one, and I think it is something we should put some staff time into, to come up with a plan for the next 60-day session and say, here, this makes more sense and gives more meaning to what you folks were trying to do. But and I think involving entities that were influential and successful in influencing the legislature on the independent's ability to vote in a primary is a good thought. But again, spend some time on it over the next year and see if we can get it done in a meaningful way in the next several years, as that works. So,
I think Gary might have had a comment.
oh, I'm sorry, I didn't see you down there.
Yeah.
Gary?
Well, being the newbie on the block, when I first, and Jeremy's not here, so this works out well. When I first went up to Santa Fe to meet the staff and everything, and I asked him, I said, what can I do to become the very best commissioner that I can be? And he said, the minute you walk into this position, you forget that you're a Republican, you forget you're a Democrat. You're to decide these cases on the merit as you see them. And perhaps the legislature knew what it was doing when it set this thing up. I don't know, I was not there. But we don't have a solution. We don't have anything to say, well, let's do this instead of what's being done now. So I agree with the chairman and what everybody else is saying, that the short session, we'd probably get nowhere, and perhaps in the long session, we'd get nowhere. But I can tell you from just, again, limited experience, I watched I guess when Jeremy appeared before the legislative committee regarding the immigration cases a couple of months ago, he completely diffused an individual Republican from the East Side, completely diffused that person's argument when he described the way the committee operated, and that it was by party or bipartisan. And I think we need to be extremely careful if we begin to change this, because the solution could really be much worse than the problem. As far as, again, my short time on this commission, I think that Jeff's presence has been a force to be reckoned with. When he speaks, I listen. People listen. I don't think anybody sits around trying to develop quorums. If I can just get somebody else to agree with me, I can torpedo this whole thing. In fact, I've been kind of surprised when it has occurred. I think from the reaction of the other members of the commission, they've been a little surprised. Oh, well, but the rules are the rules, and the rules were put in place by the legislature. And again, we don't offer a solution. So I think I think that it makes sense to look at it and look at options. But until we have a solution that we can agree on as a committee, I think that we'd probably be best just to leave it alone for now and study those options and see if we can find an option that addresses the concerns that everybody seems to have. My thoughts. Thank you.
All right, so if I can take a stab at rounding this up, it seems like we're all in agreement that we should look at this and see if there isn't a way forward that makes the non-Republican / Democrat position be one that has more than simply good thoughts towards the input and has a meaningful vote in things. I think that's the one point we all agree on, and perhaps charge staff. That would mean you, Casey. I think that falls under your guidance to figure out how you want to look at it and spend time with the individual commissioners and see if there isn't a way forward to come up with a couple of propositions that make sense in approaching legislators and the executive, whether it's in its current state or in its subsequent state. But, that seems to me to be where we are. Does anybody want to modify that, or should we just go forward and see what staff can come up with that sort of vague direction? Yeah, Jeff.
I think that's a real good idea. I've got two comments. One, if local government are going to be authorized to, in a sense, create their own ethics commissions, I think that many of them will look to the state ethics commission to see how we operate, and they may want to copy what we do, how we do it. Sort of an easy way to, okay, we're going to have 7 people. This is how we're going to select them, blah, blah, blah. So I think it is important that whatever we decide, that we understand it'll probably not just be for how we operate, but it will be copied by others around the state. And then my final thought is if the decision is not to give the independent commissioner a vote, then I think that some type of monetary compensation at a rather large amount should be considered.
It will be considered, I'm sure.
Thank you.
Seriously.
Yeah. All right. Thanks, everybody. Item 6, Casey, advisory opinion 2025-08. Good morning again.
Chair, Commissioners. You have two advisory opinions in front of you today. Unfortunately, they both have in the title that they are 2025-08. So this is advisory opinion 2025-08, ethical concerns for legislator as business consultant. So this request came from a legislator. The legislator provided a proposed consulting agreement with a company and asked for our opinion on whether there were any ethical concerns with entering into this sort of an agreement. In reviewing the agreement, there were really two provisions that were concerning looking at the ethical requirements for legislators. So the first was under the conflict of interest clause. There it said, the consultant agrees not to undertake any engagement, lobbying activity, or representation that would be directly adverse to the company's interests or that could reasonably compromise its duty of loyalty to the company without the company's prior written consent. And that provision went on to say that the company reserved the right to terminate the engagement immediately if a conflict arises, then the company's sole discretion cannot be adequately resolved. It did not have a comparable provision for the legislator if they ran into a situation where there was a a conflict that couldn't be resolved. This provision raises concerns under Section 3 of the Governmental Conduct Act, specifically subsections A and C. Subsection A of Section 3 provides that a legislator is required to keep their legislative position as a public trust, that they hold their position on behalf of the public, that they are there for the public benefit, and not to serve private interests or private benefit. Section 3C talks about a legislator's duty to avoid the abuse of office and to avoid undue influence. And the abuse of office and undue influence, looking back over old case law, has been termed in several different claims, that it's arisen in the context of misconduct in office, malfeasance in office. And really what all of these come together as is in conjunction with the public trust is that the legislator owes a duty of care and a duty of loyalty to the public, that in sitting in that position, they owe those duties. And this provision in this potential contract really potentially put the legislator in an untenable position, where if, for example, something came before the legislature that perhaps was good for the legislator's constituents, but directly adverse to the company's interests, then at that point there's this divided duties of loyalty. And so the opinion walks through those two and explains really by accepting a position like that, it would be inconsistent with their duty to take reasonable efforts to avoid undue influence. And so that's the first provision of concern. The second provision was under the scope of work. And the scope was really broad, and because of that, it wasn't entirely clear what exactly the legislator was going to be called to do. But the language said part of the scope was outreach and action with respect to government relations at the New Mexico executive and legislative branches. And because of the breadth of that, it raised several potential concerns under different laws. The first one being Section 9 of the Governmental Conduct Act. Section 9 prohibits legislators from appearing for, representing, or assisting another person in a matter before a state agency. And state agency is defined very broadly. It means any branch, agency, instrumentality, or institution of the state. And so that would include both your traditional state agencies, your executive agencies, but it would also include the legislative branch itself, the House of Representatives, the New Mexico Senate. And so there are two exceptions to this general prohibition. The first one is if that representation is not for compensation. So for example, if a legislator writes a letter to a state agency on behalf of a constituent, isn't getting paid for it, says, hey, this issue's come to mind, like, would please take a look at this. That would be under that uncompensated exception. But here the agreement contemplated that the legislator would be compensated. So it wouldn't fall under that exception. The second exception is when a legislator is an attorney or other professional making the appearance or providing the representation or assistance while engaged in the conduct of the legislator's profession. And the commission has looked at this before, looked at the statute's relationship with other statutes, with its legislative history, and really focused on what that means is a legislator would have to be a licensed professional regulated by the state in order to qualify for this other professional exception. And so nothing in the facts suggested that that the work to be performed was as a holder of a professional license. But if the legislator in fact was a licensed professional and was engaged in the conduct of their work, they would be permitted to do so long as they don't make references to their legislative capacity, don't use legislative stationery, email, or other indicia of their legislative capacity. The other concern under this very broad scope of work is whether or not it encompasses attempting to influence other legislators. Again, it said outreach and action with respect to government relations at the executive and legislative branches. So this potentially implicates the lobbying Regulation Act. Lobbying is defined as attempting to influence an official action or a decision related to legislation. But the Lobbyist Regulation Act specifically excludes from the definition of lobbyist a member of the legislature, the staff of any member of the legislature, or the staff of any legislative committee when addressing legislation. And so as a general matter, the legislator would not be required to report or register under the Lobbyist Regulation Act. With the caveat, there is a footnote drop 24 that says there's an arguable interpretation that if the legislator is lobbying for official actions, even despite the prohibitions under Section 9 or somehow within those prohibitions, that there's an argument they would no longer fall under the exception. But given how narrow that circumstance was, the opinion doesn't delve into that too much. More concerning is Article 4, Section 39 of the New Mexico Constitution. And this is known as the bribery clause. And there are a couple different provisions in it, two of which are implicated here. The first one provides that a member of the legislature who shall vote or use his influence for or against any matter pending in either house in consideration of any money, thing of value, or promise thereof shall be deemed guilty of bribery. You know, on its face, there's nothing in this agreement that suggests that this legislator would be guilty of bribery, but they would need to be very cognizant that by accepting money to work on legislative matters, that they weren't crossing that line into accepting money related to their own vote, their own influence. The second concern, you know, there are lots of things that lobbyists do. They provide lunches, they provide education, they do lots of things. And if part of the outreach and action involved the legislator, the requester, offering a thing of value, privilege, or personal advantage to another member of the legislature, it potentially implicates the second prohibition in the bribery clause, which prohibits a member of the legislature from directly or indirectly offering, giving, or promising money, thing of value, privilege, or personal advantage to any other member of the legislature to influence him to vote or work for or against any matter pending in either house. And so those really just flagged sort of if this scope expanded to influencing other legislators or to matters that the legislator themselves worked on, they would need to be very careful not to violate the constitutional provision. This provision also potentially, or the consulting agreement generally, may implicate Section 1016(6) of the Governmental Conduct Act. That prohibits a legislator from disclosing confidential information acquired by virtue of their position with the state agency for another's private gain. So, for example, if the legislator learns something in committee that potentially affects the company or affects their area of expertise, whatever it might be, they need to be careful not to share confidential information under the agreement. Finally, is the Financial Disclosure Act, which requires certain disclosures of income. All of you are aware you do this annually. I've received a suggestion to modify this to make it sort of more of a general statement of what the requirement is. And so for this final section, Section 3, the language we propose is the Financial Disclosure Act would require the legislator to report information and the source of gross income that exceeds $5,000 on the annual financial disclosure statement filed with the Secretary of State. And in order to sort of track that modification, I'd also suggest amending the short answer at the very beginning on page 2 of the opinion. So the last statement would read, if after considering application of the foregoing provisions of law, the legislator decides to enter into the proposed consulting agreement, then the legislator would also be required to report gross income of more than $5,000 received as a result of the agreement on the annual financial disclosure statement reported to the Secretary of State. And with that, I will stand for any questions.
Thank you. Is there a motion, a second to adopt the advisory opinion as set forth?
Move to
So
adopt.
Thanks. Moved and seconded. Discussion, questions? Anybody?
Very thorough, very well done.
It's great.
Thank you.
Yeah,
Good
yeah,
job.
yeah. You're exceeding your very high expectations, our very high expectations. All right, there's no further discussion. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes,
Commissioner Castillo,
Yes.
Commissioner Klingman,
Yes,
Commissioner McMillan is excused. Commissioner Villanueva,
Yes.
and the chair votes yes. Thank you very, very much, Casey. And then 2025-09, which is the next matter.
Chair, Commissioners. The first edit is to the title. This will be 2025-09, not 2025-08, training conference for state employees paid for by contractor. The request here came from a chief procurement officer and purchasing manager for a state agency. The CPO indicated that the agency has a contract with a company for millions of dollars, and that the company wanted to provide an all expenses paid trip for a training conference for several of the staff members. And the question was whether the company constitutes a restricted donor under the GIFT Act, and whether agency staff would be permitted to accept such all expenses paid trips to the training conference out of state. So the answer to the first question is yes. The definition of restricted donor includes contractors with a state agency. In which case, for an item, a gift over $250, there has to be some sort of exception in order for the contractor to provide that to a state employee. And so the GIFT Act has 10 specific kinds of payments or transfers that are exceptions. One of them is reasonable expenses for a bona fide educational program that is directly related to the state officers or employees' official duties. And the commission has looked at this exception before. The context of the prior review was in an opinion where legislators were being provided trips to go, I believe it was look at a refinery. And the commission was asked to determine whether or not that trip would be permissible under the bona fide educational program. And so the commission, in previously looking at this exception, broke down the requirements into 3 elements. In order for a restricted donor to make payments in excess of the gift limit, it must be 1, for reasonable expenses, 2, for a bona fide educational program, and 3, that program must be directly related to official duties. And in determining what reasonable expenses include, the commission determined the costs of flights, meals, refreshments, and lodging are considered reasonable expenses. And to be careful about that, it matters where they are, how long the stay is, what market rates are. For example, booking a hotel in Santa Fe for the week of Christmas is going to be a very different cost than booking a hotel in Jal in June. That looking to those locations, the duration of the stay, that really all goes into whether or not an expense is reasonable. This is something that the Attorney General's office has also looked at. Again, it was the same question of whether or not legislators are permitted to go on a program paid for by I don't believe it was a contractor, but by a company that was, I think, trying to have business in the state. And in those opinions, one of them permitted a 5-day educational site visit to the Netherlands, where they paid for legislators' travel, food, and lodging. And again, it tied back to, is it reasonable and is it directly related to the official duties as a legislator? And so turning to the question here, so long as the expenses are reasonable, this is going to be an out-of-state trip. And so looking to other get quotes in the area, make sure that you're not staying at the Ritz-Carlton when it's not necessary, that this was for a training conference. that they would be, the contractor would be permitted to pay the costs of flights, meals, refreshments, and lodgings for state employees to attend a training conference, provided that it's directly related to their official duties. So with that, I will stand for any questions.
Thank you. Is there a motion and a second to adopt the advisory opinion as suggested?
So moved.
So moved.
Thank you. Discussion and questions? Yes, Commissioner Bluestone? Stuart, you're muted. You're still muted. There you
Sorry
go.
about that.
That's
Okay.
okay. Good.
It's an excellent opinion, and I thank you for fine work again, Casey. My question relates to what disclosures will be made of the amounts of money that were spent, and how is that publicly disclosed, and should the opinion address the form of disclosure so that there can be some at least public check on the reasonableness of the expenses? I mean, I don't quarrel at all with what's said in the opinion. I'm just wondering, is there a mechanism in the GIFT Act itself or in the Financial Disclosure Act, or how would disclosure take place on the expenses of this kind of an educational experience?
You know, Commissioner, Chair Commissioner Bluestone, there's nothing in the GIFT Act that requires that sort of a disclosure. The Financial Disclosure Act would require it only if there were something like for an employee who doesn't have mandatory disclosure requirements, does have obligations if one of their financial interests is something that will come before the agency. I don't really think that this would fit under that definition. So the answer really would be, I mean, there isn't particularly a form for disclosure. Of course, if this is going through the agency, that would be something that would have to be handled by the chief procurement officer, by the regular financial tracking. But if it just went directly through the individual, I'm not sure that there's anything specific. There's no specific disclosure required. So,
well, I wonder if we should comment on that. I mean, do you think it would be appropriate to note that, at least in a footnote, in the opinion, and that it would seem to me that it's in the public interest to know the expenses that are made. It may be entirely lawful as long as they're all reasonable expenses, but there's no way of knowing what the expenses are unless there's some disclosure about it. And I'm wondering whether you think it would be worthwhile to comment on that in some form in the opinion.
So Chair Commissioner Bluestone, I think that puts us sort of back in a discussion that we had in the last commission meeting, which is, that's not a consideration that we reviewed in conjunction with this opinion. I think it's probably worth considering whether or not that's something that the commission ought to recommend to the legislature. That my suggestion would be to have staff sort of explore that idea and what might be the best venue for recommending that sort of disclosure. Really considering where that disclosure might live. Perhaps it is in the GIFT Act, that if you fall under one of these exceptions, you have to disclose it through public notice somehow, or whatever that might be.
Mm-hmm.
That might be sort of a more productive way to get that information moving forward. That would be my suggestion.
Yeah, I think that's a good suggestion. And I'm wondering whether you think it's worthwhile noting before we release the opinion that we're acknowledging this issue, and that we would like to consider how this could best be addressed but that we do believe that disclosure is still an important part of the Gift Act's statement here, that it's appropriate to do it as long as the expenses are reasonable, but there should be some way of allowing the public to see that the expenses are in fact reasonable. I don't have anything particular in mind in terms of language or how to address it, but I just wonder if you think we should note something in this, and then, as you say, consider later whether we want to make a recommendation for an amendment to the Gift Act to do it. But I think to acknowledge the issue could be helpful. I mean, I don't have strong feelings about it, but I think the idea of getting some recognition of the issue is worth considering. I hadn't thought about it until you were going through the opinion just this morning. I apologize for that.
Chair, Commission, you know, I would recommend either issuing it because we don't have any language on that, and we're not entirely sure sort of where this might go or what that recommendation might be. Because it's not specifically relevant to the questions presented, it would be my recommendation to either issue as is, or hold it until the next commission meeting when we can have an opportunity to review what that might look like. The sort of having a placeholder in there, you know, it might be that we look at it and say, oh, there is this other provisional law that might come into effect, or really this should go into the annual report, or wherever that might go, that because we don't have language to that effect right now, that would be my suggestion, is to hold off on that, or hold the opinion until we have an opportunity to look at that.
I don't know. Any thoughts on from anybody else?
My preference is to release it as is. It is somebody seeking an opinion, and further delaying it, I don't think does us any good, particularly because we're going into a what if. It's sort of an AI question. We all know it's there, but what happens in the end? And we don't know that yet. We should, I believe, answer the question presented to us and answered by the opinion, with the understanding that we can further develop, as we do with many things, any possible amendments to what we need to look at down the road. But this is a specific question that somebody has asked to be answered, and I think we owe them that when we have the ability to do that, and we do.
Yeah, and what we're saying here is consistent with what we've said before.
Exactly.
Anyway. You know,
Yeah,
it's
exactly.
all as long as they're reasonable expenses. But I do like the idea of having some disclosure of what the expenses are. So I'm fine letting the opinion go as it is now. And I don't know, it's probably not appropriate to go back and amend our annual report and put in another disclosure thing, but I'd like to get some feedback from staff about what would be the best way of addressing the disclosure of these kinds of expenses, and maybe in a future meeting or future recommendation to the legislature, we can propose something. But I would like to see that issue addressed. So I'm fine going ahead with it as is, and asking the staff to come back to us with a recommendation on how to provide for disclosure.
Thank you. Does that work for you, Casey? Yep.
Sure.
Anyone else? All right, great. Thanks. There is a motion, a second, to adopt the advisory opinion in 2025-09. Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes, and good job.
Thank you. Commissioner Klingman?
Yes.
Commissioner McMillan is not here. Commissioner Villanueva?
Yes.
And chair votes yes. Thank you. The motion carries. The advisory opinion shall issue. Thanks, Casey. All right, Amelia, is there any public comment?
Thank you, Chair. Yes, if you are a member of the public and would like to make a comment, please now come off mute and state your name. I do see one member of the public here. So if you'd like to speak, Rich, please do so now.
All right.
Chair, I think
Anything?
that's back to you.
All right. Thank you. Is there a motion to go into executive session pursuant to 10:15 1H3 and 10:15 1H7?
So
So
moved.
moved.
Thank you. There's a motion and a second. We will go ahead and move into executive session, the mechanics of which will be on your screen in a moment, and we'll start by taking a 5-minute or so break.
Are we going to vote?
Oh, yes. I'm sorry. Is there any opposition to the motion to go into executive session? No, thanks. So, yeah,
No.
okay. We will go into
Sorry,
executive
that
session.
should be a roll call vote, just for the record.
Okay, well then let's do it that way. I'm anxious to get to the break, as you can't tell. Commissioner Baker,
You bet.
Commissioner Bluestone,
Yes.
Commissioner Castillo,
Yes.
Commissioner Klingman,
Immediately.
Commissioner Villanueva,
Yes.
the chair votes yes. Okay, we'll go into executive session and start our break. Okay, can you pop that screen up again?
Yes, Chair, I will do that. It is making me wait 30 seconds though, so if you want to
Okay.
take a break and when you're
Okay.
back, you'll have the option to join.
Thank you.
All right.
Where'd you
So we're
go?
off the record?
I don't think we're ever off
no.
the record. Yeah.
Well, I just wanted to say that on those out-of-state trips, I think we ought to have a requirement that a member of the Ethics Commission has to go along just to make sure everything is on the up and up.
Adult supervision. There you
There
go.
you go. All right, see you in a bit.
All right, I will state for the record that the matters discussed in the closed meeting were limited only to those specified in the motion for closure pertaining to sections 1015 1H3, 1015 1HCH or H7 to discuss those matters. Okay, we are back in open session and we will now move to agenda item number 11, Becky and Zach.
Chair and Commissioners, in 2024 NP06, staff is requesting dismissal of the complaint against Sajid Sheikh and an issuance of a warning letter to Mr. Sheikh.
Thank you. Is there a motion and a second to adopt the dismissal and warning?
So move.
Second.
Thank you. It's been moved and seconded. Is there any discussion? Hearing none. Commissioner Baker? Commissioner Baker, you're muted. Thumbs up was his. There you go. Okay, a thumbs up from Commissioner Baker. Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner Klingman?
Yes.
Commissioner McMillan is absent. Commissioner Villanueva?
Yes.
And the chair votes yes. The motion carries. The matter will be dismissed with the appropriate warning attached therewith. And item number 2.
Thank you, Chair. Commissioners, in the matter 2025 NP14 regarding the Notary Commission of Natalie Archuleta, we are requesting a dismissal in this matter.
Thank you. Is there a motion and a second?
So move.
Second.
Moved and seconded to adopt the dismissal recommendation of staff. Is there any discussion? Hearing none. Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner Klingman?
Yes.
Commissioner McMillan is excused. Commissioner Villanueva?
Yes.
And the chair votes yes, the matter will be dismissed. Thank you both. All right, on to number 12. Zach, these are all yours. So at your suggestion, we will move through them.
Thank you, Chair. Commissioners, in this first complaint, number 2025-30, we are requesting a dismissal due to the insubstantiality of the claims presented in the complaint.
Is there a motion and a second?
So
So
move.
moved.
Second.
Thank you. Moved and seconded. Any discussion? Hearing none. Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner Klingman?
Yes.
Commissioner McMillan is not with us today. Commissioner Villanueva?
Yes.
And the chair votes yes. 2530 is dismissed. Roman numeral 2.
Thank you, Chair. Commissioners, in this matter, complaint number 2025-31, Phoenix v. Denham, we are requesting a dismissal due to lack of jurisdiction.
Okay, is there a motion and a second to dismiss for lack of jurisdiction?
So moved.
So moved.
Thank you. And any discussion? Hearing none. Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner Klingman?
Yes.
Commissioner Villanueva?
Yes.
Chair votes yes. Commissioner McMillan is absent. Item number 3.
Thank you, Chair. This is complaint number 2025-32, Sanchez v. Cage et al. For this complaint, we're requesting a dismissal for various reasons, including both a lack of jurisdiction over one of the named respondents and the insubstantiality of claims presented for another respondent.
Thank you. Is there a motion and a second to dismiss as suggested by staff?
So move.
Second.
Thank you. Any discussion? Excuse me. Hearing none. Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner Klingman?
Yes.
Commissioner McMillan's excused. Commissioner Villanueva?
Yes.
And the chair votes yes, the matter is dismissed. Thank you. Roman numeral number 4. And I believe you're recused on this matter, Commissioner Baker?
That's right. Thank you.
Okay. Go ahead, Zach.
Thank you, Chair and Commissioners. Complaint number 2025-33, Sanchez v. Helton. Here we're requesting a dismissal due to lack of jurisdiction since the respondent is a county sheriff.
Thank you. Is there a motion and second to dismiss for lack of jurisdiction?
So move.
Second.
Thank you. Any discussion? Hearing none. Commissioner Bluestone,
Yes.
Commissioner Castillo,
Yes.
Commissioner Klingman,
Yes.
Commissioner McMillan is absent, Commissioner Villanueva,
Yes.
and the chair votes yes. Thank you. Numeral 5.
Thank you, Chair and Commissioners. This is complaint number 2025-34, Villegas v. Henny. Here we're requesting a dismissal due to the insubstantiality of the Government Conduct Act claims which have been filed against the respondent, who is the Secretary of the New Mexico Environment Department.
Thank you. Is there a motion to dismiss accordingly?
So move.
Second.
Thank you. It's been moved and seconded to dismiss for insubstantiality. Any discussion? Hearing none. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Klingman.
Yes.
Sorry, Commissioner Castillo,
Yes.
Commissioner McMillan is absent, Commissioner Villanueva,
Yes.
and the chair votes yes. Item number 6.
Thank you, Chair. Commissioners, this is case number 2025-37, King versus the New Mexico Regulation and Licensing Department. Here we are requesting a dismissal because the commission does not have jurisdiction over the Regulation and Licensing Department as an entity on its own.
Thank you. Is there a motion second to dismiss for lack of jurisdiction?
So
So
move.
moved.
Thank you. Any discussion? Hearing none. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Castillo,
Yes.
Commissioner Klingman,
Yes.
Commissioner McMillan is absent, Commissioner Villanueva,
Yes.
and the chair votes yes. Thank you. Item number 7.
Thank you, Chair, Commissioners. This is case number 2025-38, Leyva v. Coleman. Here we are requesting a dismissal due to lack of jurisdiction. The respondent in this matter is a village police chief, and so the commission does not have jurisdiction.
Thank you. Is there a motion and a second to dismiss for lack of jurisdiction?
So move.
Second.
Second.
Any discussion? Hearing none. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Castillo,
Yes.
Commissioner Klingman,
Yes.
Commissioner McMillan is absent, Commissioner Villanueva,
Yes.
and the chair votes yes. Okay, Roman numeral 8.
Thank you, Chair, Commissioners. This is case number 2025-39, DeHoff v. Gallegos. In this matter, we are requesting a dismissal due to the fact that the respondent is the Sandoval County Assessor, and the commission does not have jurisdiction over that subdivision.
All right, thank you. Is there a motion and a second to dismiss for lack of jurisdiction?
So
So
moved.
moved.
Thank you. It's been moved and seconded. Any discussion? Hearing no discussion, Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Castillo,
Yes.
Commissioner Klingman,
Yes.
Commissioner McMillan is absent, Commissioner Villanueva,
Yes.
and the chair votes yes. Very good. Thank you very much, Mr. Goodrich. Next item is 13, discussion of next meeting, which per usual would be on February 6th, 2626. Everybody okay with that?
I'm going to be out of state, but
Perfect. You can't vote anyway.
no, you,
Rub it in. Rub it in.
Mr. Chair, you are so direct, concise. You hit the
Pressing.
nail on the head every time.
So will you be here on the 13th?
Yes, but
Is
don't
everybody
wait
okay?
on me.
No. Is everybody okay? Now we can move to the 13th unless it wreaks havoc on the schedule, which it doesn't appear to be. So we're going to have it on the 13th of February.
Thank you. I appreciate that.
You bet. And Amelia, any public comment?
Thank you, Chair. Members of the public, if you'd like to speak, please now come off mute, state your name, and provide your comment. I see one member of the public Rich, would you like to make a public comment today? Okay, Chair, back to you.
Thanks, Amelia. Okay, anybody have any last meaningful words besides have a safe and happy holiday season, everyone? And we'll see you next year.
I second that.
Sounds good.
Right. Okay, everybody, nice to see you all as usual. Look forward to seeing you in the coming year. We are adjourned.
All right,
All right.
thank you all.
Happy